spaces if you want them. Yeah. All right, we good?
Yes.
Feel confident that we know what we're doing now?
Yes.
Okay, so here we go. Now I'm going to do a court case as though it was like a presentation that you guys are going to be doing next week. So I'm going to be representing both the plaintiff lawyer and the defense lawyer. And so in this case, I won't be sitting down and standing up, but the two lawyers would be sitting here at the front of the room. And so so let's say if I'm going to be the defense lawyer, I'm going to be giving the background speech. I'm up here first. Plaintiff lawyer will be sitting there while the defense lawyer is giving the background speech, and then they just trade off for when they have to stand up and give their speeches. Okay, we good? Set? Ready? Okay, here we go. So I'm going to start off giving you the background of the court case of Brown versus Board of Education. This is a court case that was actually a compilation of 5 different court cases put together. So Brown versus Board of Education was just the one that was the primary argument, the primary case that was being argued, but it actually encompassed court cases challenging the segregation of schools in Kansas, South Carolina, Virginia, and Delaware. The NAACP basically took up these cases, that's the National Association for the Advancement of Colored People, saying that really segregation, especially in the school setting, was a violation of the 14th Amendment. And so really this is a case that has to do with the right of equal protection of the laws and equal access and opportunities. So that's the main issue at stake in this court case. The core question was really what kind of discrimination is fair versus what kind of discrimination is not fair. In this case, the precedent that had been established already that the schools had segregated schools under was the court case decision of Plessy versus Ferguson from 1896. That basically said that there was a guy who had tried to get on, there were the different train cars for whites and for blacks, and a guy who was black tried to get on a white train car, and they said, no, you cannot, you have to get on the black train car, and the justification for why that was fair discrimination was the court said that they were separate but equal facilities. So that concept, the idea of separate but equal, was the precedent of what could be claimed legal and fair discrimination up until the Brown versus Board of Education court case. So basically, the claim was as long as you provide equal facilities, there's 2 train cars, it's not like they didn't have a train car for black people, then you could have segregation, that legal separation of races. So that was the precedent going into this court case. The main parent, Oliver Brown, was the father of a 3rd grader named Linda in Topeka, Kansas, and Topeka, Kansas was suing to see if they could get their kids admitted to the white school that was closer to their homes. So the bottom line is that there were, in Topeka, Kansas, there were black and white schools, but sometimes the black kids had to travel farther away to get to the schools. And so there was a claim that these schools were unequal, and that's and basically they were denied, the kids were denied access or entry to the white schools that were near their home, and that's why they brought the lawsuit. So that's the background of how this court case came to be in the first place. So that's my background speech. So now I'd sit down, and the plaintiff lawyer would stand up. So as the plaintiff lawyer now, I am representing the interests of Brown and all of the people bringing the lawsuit against the school board of Topeka, Kansas. So here are my arguments as the plaintiff lawyer on behalf of Brown and all of the parents that are trying to get their black children admitted to the white schools. Segregation is inherently leading to inferior accommodations, services, and treatment of black students. In the case of Linda Brown in particular, she has to get up at 7:40 each morning and walk through a dangerous train yard, and she's only in 3rd grade. She often has to wait in snow and rain for up to an hour at the bus stop, and then when the bus brings her to her school, sometimes she has to wait up to an hour and a half before the school actually opens. So she's walking 6 blocks away, taking a bus an extra mile to a school where she has to wait with no supervision. It could be dangerous, and the white school down the road is much closer. It's within the neighborhood that she lives in, and it's much safer. So that's one of the first problems of why there's unequal accommodations. One of the other issues that are why the Browns and all of the African American parents should win this case is also that around the world, scholars are beginning to recognize that there is no scientific basis for racism and segregation. In 1950, the UN, through UNESCO, the economic and social body of the UN, issued a report called the Race Question, where they outright denied that there are scientific arguments that justify racism. And so the scientific and cultural opinions are beginning to shift on this issue. Another thing is that college professors in America have been researching this issue and the impacts of segregation on students' ability to learn and to succeed. And one of the issues that's been brought up by these professors is that there's a tendency for people to live up to or down to the social expectations of what they're capable of. And so when black students go to a school that is where they are not mixed with their white peers, the expectation is that they're only going to achieve lower jobs in life. And so students tend to not perform as well because of this social expectation. Another issue that's brought up by the education department chair at the University of Kansas City also says that when there are 90% of our society is white and that colored children cannot intermix and learn with white people, then their ability to learn how to navigate in society is significantly limited. If they don't learn how to interact with people within the democratic setting of a school, how can they learn to live and work with them out in regular life? And so their informal education is inherently hindered. Another major issue that really, at the end of the day, is probably one of the most important things is Kenneth Clark, who did research, sociological research, on white and black students throughout schools where they were segregated. And he gave students a series of different dolls. He would give students white dolls and black dolls. And he would ask the students, which dolls are prettier? Which dolls are nicer? Which dolls are like you? And over again, all of the students, black and white, would choose the white dolls as the prettier dolls, as the smarter dolls, as the good dolls, and as the dolls that looked like them. What the findings of this study indicate are that black children are growing up in a society where they inherently associate white with goodness and black with badness. And to be forced to be in segregating settings means that they are going to continue to grow up in a system where they believe that being black makes them inherently inferior, and that in and of itself makes it harder for them to learn. And so no matter how nice the physical building is, no matter how many buses the school can supply, no matter how many good teachers the school district can supply, it will never be an equal educational setting because the fact that they are separated means that black students will graduate with an inherent inferiority complex that diminishes their capacity to be equally functioning citizens and workers in American society. And that is the majority of our case as the plaintiff lawyers. Now I would sit down as the plaintiff lawyer. The defense lawyer would stand up. All right, so as a defense lawyer, I am representing the school board of Topeka, Kansas, and the other school boards in these other states that are bringing cases as well. And we are going to basically premise our argument on two main facts. One is that the tangible physical facilities and resources of these schools are substantially equal. In other words, there are buildings for both black and white schools. They both have bathrooms and cafeterias and gymnasiums. There are buses, so even if a student has to travel a farther distance, the school still provides a bus to make that possible. The schools provide equal curriculums to the teachers who teach in both the black and white schools. They also provide staffing. In fact, the average class size of kindergarten schools for white schools are bigger at 42 than the kindergarten schools for black children, which is the average size is 25. So in fact, you could argue that the white kindergartens have a harder time because with 42 students in a class, a teacher can't possibly provide the same education that she can provide to 25 students. In fact, one of the plaintiff's witnesses themselves even said that he felt that the black teachers at his daughter's school were just as good as any single one of the white teachers at the white schools. That in and of itself shows that even the plaintiffs believe that they have equal resources. Furthermore, the other major argument is that states and local communities have the right to make their own laws about whether they want cultural assimilation or not. That the school board is not here to dictate the customs of the people, and that there's no evidence that the majority of citizens of Topeka, Kansas want cultural assimilation in their community. So if it's an issue of the cultural norms that we are supporting, we as the school board should we should be servants of the citizens of the city that we live in and do what they believe they want to promote culturally for their children. Lifestyle issues belong in the hands of the state and the people and the Democratic majority, not the school board or the government to dictate that beyond what we do to carry out the will of the majority. And that is those main arguments for the defense lawyer. Okay, now I'd sit down as defense lawyer. All right, now plaintiff would get up, and plaintiff is going to give you the aftermath, what really happened. So here's what happened in real life. This was a unanimous decision. The plaintiffs won 9-0, which is actually pretty unique for these cases. The major arguments that persuaded the court were that by the 20th century, public education had become an essential component of a citizen's public life. They could not participate in democratic citizenship. They could not gain professional training to succeed in life without a public school education. And so, first of all, education is primarily important, maybe more so than other places where segregation could happen. It's not something you could opt out of or choose out of, like maybe going to a restaurant. The Clark-Dahl test evidence was incredibly compelling. In fact, the court didn't even really talk about whether the school building, the tangible facilities, the buses, the buildings, the curriculum were equal or not. That wasn't what the court was concerned with. What they were concerned with was the danger of the inferiority complex that adversely affected black children's ability to learn. If they thought they were stupid, why should they try? And that was inherently a problem. And so the facility itself, even though it might have been the same size or whatever, was not providing equal opportunity to education. Within a year, the court had said in 1955, they followed up the case by saying that all schools needed to integrate with all deliberate speed. But this is interpreted widely differently by schools throughout the South. Even within our own community, Swan versus Charlotte-Mecklenburg Board of Education is a 1971 court case that decided that busing was a fair way to promote integration of schools. But this issue and the idea of how far a school district must go to promote integration and an atmosphere of healthy intercultural learning for students is still an incredibly controversial issue in our country today. And one of the court cases you're going to hear about later in these presentations, Regents of the University of California versus Bakke from 1978, and then the cases against the University of Michigan that you'll hear after that will also have to do with how this issue plays out at the collegiate level in state universities. But this is really a significant turning point for the civil rights movement because it's the first time really that separate but equal of Plessy versus Ferguson is overturned. Okay. The end. Could you hit stop on the button for me?